All right, let's bring in our think tank tonight. Joining us in Minneapolis, civil rights and trial attorney Lee Hutton is with us. In Atlanta, Georgia, criminal defense attorney Michael Bixon. And in the Bronx, in New York, criminal defense attorney Renee Hill. Great to see everyone tonight. Renee, let me start with you. Toxicology, video of something on George Floyd's tongue, observations, questions by the officers on the body cam video. Do you think the defense has a good foundation here to make a legitimate argument that George Floyd was under the influence of methamphetamine and fentanyl that day?
Well, they certainly do, Vinny. They have the toxicology report from the medical examiner that they're going to use to their advantage. And, this is the state's evidence, and the defense is going to use it to their advantage, which is something that the defense loves to be able to do. And the toxicology report shows that there were narcotics in his system, and that is certainly a very good foundation for them to begin with their defense. Absolutely.
Lee, how much of a leap is it from someone doing drugs to someone overdosing on drugs?
Well, I can tell you the defense, as you stated earlier, is not going to try to prove anything. What they're trying to do is throw mud into a clear glass window, so the jury looking through that window pane can't really tell if it's a duck or a horse or what's on the other side. And so, this is kind of, playing a game with show the red light and kind of have the cat follow it and confuse the jury to do reasonable doubt. Now, what they have to the advantage is that they have a Hennepin County medical examining report that lists out fentanyl, and that's going to be something for the jury to consider. And ultimately, the state has to focus them on causation of death, which was also in the report, asphyxiation.
All right, Michael Bixon, I want you to take a listen to what Eric Nelson, the attorney for Derek Chauvin, he was making some arguments in court. And what came up in the arguments were some discoveries that the defense made of methamphetamine with fentanyl in it that was found in the squad car with George Floyd's DNA on it. Take a listen.
In looking at those initial pictures, you can see pills in the center console of the Mercedes-Benz, and where Mr. Floyd was, where the officers believed his hands were in that instance. And the state initiated and those pills were not seized in that initial search. They were not seized and tested, identified, etc. Those pills formed caused the state, or those photographs caused the state to execute a second search warrant on the Mercedes-Benz to take those pills. And in the course of taking those pills, they also did a more thorough search where they basically opened every single thing in that and documented every single item that was in the vehicle, including Suboxone boxes and other drug paraphernalia that was contained in the Mercedes-Benz. They took those pills, they tested those pills at the Bureau of Criminal Apprehension, and those pills revealed that they were methamphetamine and fentanyl mixture. It's my understanding, and I don't know if it's in the 1,000 pages I've received since Monday, last Monday. One of those pills was sent to a lab in Pennsylvania for quantification in terms of what is the degree of methamphetamine versus fentanyl in those pills. And that was the second search of the Mercedes-Benz. So as we're looking at the photographs of Squad 320, and you start to notice that there is this white residue and these items that were all over the back seat of that car, you start wondering, what is this? So the defense requested to inspect Squad 320, and of course the state complied and permitted us to do that. Myself, Mr. Gray, representative from Mr. Plunkett's office, and then Mr. Pauly was on the phone as this was being conducted, and 2 BCA agents were there. I am not a law enforcement officer, and I'm certainly not a crime scene forensic technician. What I saw was immediately apparent that what was on the back seat of this squad car was chewed up drugs. It looked like chewed up pills. On the floor, in addition, there is a near complete tablet. It's partially dissolved, but very similar. And it's clear that this is a pill. These things would not normally be in the backseat of Squad 320. You can actually see in the body camera footage, as they're attempting to put Mr. Floyd into Squad 320, the backseat is perfectly clean, or there's none of that apparent residue in the vehicle. Ultimately, then, they execute a second search of Squad 320. By they, I mean the state. They seize these items. They test these items both in terms of their the drug makeup or the nature of the drug, as well as for DNA. And it's Mr. Floyd's DNA on these drugs, and it's primarily methamphetamine with potential traces of fentanyl.
All right, Michael Bixon, evidence that there are methamphetamine and fentanyl in the Mercedes where George Floyd was, and then in the squad car where George Floyd was with George Floyd's DNA on it. What does the defense argue?
Well, I think, first of all, one of the best arguments that they now have is that the state either negligently missed this or they intentionally missed this. And I think it's a big part of, aside from the drugs, finding the drugs, because it talks about how complete this investigation actually was. And making that kind of argument in front of a judge or a jury goes a very, very long way. Now, the actual finding of the drugs, I think, immensely helps the defense's case. It builds up this argument that they're trying to go forward with, that the death wasn't caused by, any type of asphyxiation, but heart failure due to drugs and an underlying heart condition. So I think it's very good for the defense overall.
All right, let's talk more about the Hennepin County Medical Examiner. Let's begin first with the cause of death, which, if you look at the beginning of it, cardiopulmonary arrest. That's heart failure. I believe the defense will seize upon that. They're not going to focus on the complicating law enforcement subdual, restraint, and neck compression, but clearly focus on the cardiopulmonary arrest. And then Renee Hill, I want to put up a handwritten note, Dr. Baker, okay? And this note says, if he were found dead at home alone and no other apparent causes, this could be acceptable to call an OD, overdose. I'm not saying this killed him. That's what Dr. Baker is saying in writing here. But he's saying, if there was no other evidence, he could be very comfortable calling this an overdose. That's the opinion of Dr. Baker, the state's expert. If the jury believes this handwritten note, and Dr. Baker confirms that on the witness stand, is that reasonable doubt right there, going to the element of causation?
It certainly suggests that, Vinny. It certainly suggests it. It is really great fodder for the defense to use to argue with. This is the state's witness that is saying it could have been an overdose, but for the contributing factors here. He is saying but for. However, it's enough for the defense to make an argument that there are other things going on here and that it could have been a result of his ingesting something else and not the knee on his neck. It does give the defense an argument. And that's all that they need, is an argument, a reasonable argument to put forth to the jury to consider.
And that's what they'll be instructed on. But Lee Hutton, do you think the jury will evaluate it that way? That, hey, the defense just has to raise a reasonable doubt. Prosecutors got to prove it beyond a reasonable doubt. Or are they going to say, oh, it wasn't an overdose? Well, it could have been an overdose, but I really think it was the knee on the neck. It was, how do you think the jury accepts that argument from the defense, or will they accept it?
And this is where we're going to see how trial attorneys really engage themselves in the argument. So there's two things that are apparent here. Number one is that Minneapolis has had a history with police brutality and issues with Philando Castile, which was very, very high profile. Recently with Noor, which was very, very high profile. And these incidents happened in the last 5 to 7 years, and Minnesotans haven't forgot that. And so the state has an opportunity opportunity to rehabilitate their own expert in saying, look, he said that if he was in a home by himself and there was no other factors, I would conclude this. But that's not what the tape shows. The tape shows a man being restrained in a neck, saying that he couldn't breathe for more than 9 minutes. And that's a very, very substantial issue. Now, the second issue here is that regardless of the fact, we're dealing with the cultural anthropology of individuals. And what I mean by that is that you have a more diverse jury than we've ever had in Minnesota in a very diverse county. We have 4 African Americans. We have more women, and they're really young. And I think they just observe the world differently than a person in the 60s, like my parents grew up in Jim Crow and down south. They just don't see the world the same way. And so we're going to try to, we're going to see how the state deals with the new cultural anthropology of how young people are going to consider the facts as they see it, and the defense, how they're going to see individuals that propose and support Blue Lives Matter over Black Lives Matter.
All right, Michael Bixon, I have one more video to show you. And this was an argument that was just recently made by the defense, and they won the argument. This video of George Floyd's arrest from 2019, this portion of it will be in front of the jury. Let's take a look.
Okay, relax. Just undo your seatbelt. Let her take care of her guy. Just keep your hands out where I can see him. Hey! Let me... Keep your hands where I can see him. Okay? Put him up on the dash. Put him on the dash. I'm not going to shoot you. Put your hands on the dash. Put your hands on the dash. The last time I'm going to tell you that. It's simple. He keeps moving his hands around. He won't listen to what I have to say.
Put your hands on
Okay.
top of your head.
What y'all doing on your head?
Top of your head.
Okay, man.
Open your mouth. Spit out what you got. Spit out what you got. I'm gonna tase you. Spit it out. He's eating.
Don't you jerk away from me.
That was one yellow pill.
Put your hands behind your
That was one yellow pill, boss.
Okay, now slowly come on out.
Hand on
Now put your
hand on your head.
Okay, relax then. You're not going to get beat up or nothing if you just follow what we're asking you to do.
All right, Michael Bixon, that minute 13 of the video from 2019, a year before George Floyd dies, is going to be in front of this jury. How important is it for the defense? And they're supposed to use it to help prove cause of death.
Yeah, I mean, when you look at the video, I think it's crucial for the defense. It sort of shows a lot of elements, a lot of similarities between what happened this and what happened in the newer case. Obviously, you see a lot of things carry over, the drugs, the possible pills in the mouth. I know that there was cardiac issues, or his health history plays a role in this as well. So I think there's a lot of good points in this for the defense. Now, I know that the judge isn't going to allow in all of the video. There's some aspects of it that he claimed that were too prejudicial, and I think that was very fair to the state, and I think it was the correct decision. But overall, I do think this is a very helpful video for the defense.
All right, we got much more coming up with our think tank. Meanwhile, tomorrow on Court TV Live, Julie Grant will be speaking with a man who knows a lot about high-profile cases, our friend, Judge Belvin Perry. The Orange County Superior Court judge who presided over Casey Anthony's trial joins Court TV 2 p.m. tomorrow to talk about this case, the Derek Chauvin trial, and the challenges that the judge, Peter Cahill, will have as the trial begins on Monday. We'll be right back.
I'm claustrophobic. I'm claustrophobic, man. You're working with me. God, I'm claustrophobic, man.
Get in the car.
Get in the car. Can you put me in the front? Please.
No, you're not getting in the front.
I'm claustrophobic, so I was
Get in the car.
Okay, man, okay. I'm not a bad guy, man.
Get in the car.
I'm not a bad guy. Man. What's my trouble? Please, officer. Please.
Sit.
Please.
Take a seat.
Please, man. Please. No,
Take a seat.
I can't choke. I can't breathe, officer. Please. Please.
Fine.
My wrist, man. My wrist, man, please. Hey, man, where's the ground? I'm on the ground.
All right, there's part of the video. That's the body cam video where you see how George Floyd ends up on the ground. Let's bring back in the think tank Lee Hutton. Let me ask you, do you think the defense can persuade the jury or be persuasive in using that part of the video to explain how George Floyd ended up on the ground, to try to argue that there was no intention to assault or harm George Floyd? The intent was to arrest him.
They sure are going to try to, but I can tell you, and I'm going to play devil's advocate for the defense. There comes a point in time where he's on the ground outside the car, and there's nothing necessary that needs to be done to subdue the person when he has two officers on his left and right leg and another one on his neck. And where are the tactics that they could employ to calm him down? Now, Minnesota has a statute that specifically says for officers to use an objective, reasonable tactics to ensure that the force is not to the point where it's going to be deadly. And that's going to be an issue here. Did they do a little bit too much to an individual when it was unnecessary? And the legislature who wrote that statute gave a caution, and they said, be very careful with this objective, reasonable standard. And you look at the totality of the circumstances, and that's where the drugs come in. But the question is, was it reasonably objective to use this type of force?
Michael Bixon, guess what? I want you to listen to some more video again. And it's the part that we just saw, but a smaller portion, because in it, if you listen to George Floyd, before he's on the ground, before Derek Chauvin's knee is on his neck, he is saying, "I can't breathe." Let's watch it first.
Man, in the car. I'm not a bad guy. Man. Please, officer. Please.
Sit.
Please.
Take a seat.
Please, man. Please. No,
Take a seat.
I can't choke. I can't breathe, officer. Please.
Michael, do you think the defense can effectively argue to the jury and try to explain why they don't react to George Floyd when he's on the ground saying, "I can't breathe," because he had been saying that before he was on the ground?
Absolutely. I absolutely think that they're going to seize on this portion of the video where you have him talking about, "Oh, I can't breathe," because later on, to sort of explain out the officer's actions, you have to come up with a reason why they're not coming off of George Floyd. And I think so far this is one of the best ones, that they thought he was really faking it. They had someone who was non-cooperative, someone that was resisting consistently throughout this video. And then at the point where he stops, maybe they thought he was faking it. I mean, because they're going to have to come up with some explanation other than they didn't like him, So I think so far what we've seen from this, at least this small portion of the clip, they could definitely use.
All right, Renee, there's a clip from Officer Lane's body cam where we see the other two passengers that were in the Mercedes with George Floyd. And as we watch this, I want you to pay attention to their demeanor and think about whether or not the defense would want to argue to the jury that everything escalated with George Floyd because of George Floyd's actions, and to prove that, well, the two other passengers were cooperative and nothing happened to them. Let's take a look.
You have ID?
I'm on 38th in Chicago.
Man.
320 we're close for.
38th in Chicago.
About me, sir. I just came to buy the tablet, and when I bought the tablet, he didn't
Oh
work.
my God. He didn't even do nothing.
Here you go, sir.
You have ID?
No, I don't. My
You got
name's
anything with your
Shawan
name on
Renee
it?
Hill. No.
Sir.
Okay.
I just
Heard
came
I was
over to
just
get my
getting a
phone. You
ride.
see, I don't have a
Mr.
purse or nothing.
Mr. Adam
And my
knows
daughter
me.
is on her way to get me.
What's his deal?
I don't
Mr. Adam
know.
knows me, sir.
That's
His
my
deal, he
ex.
just-
I
he
don't
just-
know.
Why is he getting all squirrely and not showing us his hands and just being all weird like that?
Because he's been shot before. He don't
Well, I
wanna-
get that, but still, when officers say get out of the car,
Going
is he drunk? Is he on something?
No, he got a thing going on. I'm telling you
What
about
does
the
that mean?
police. We have problems all the time when they come, especially when that man stood that gun like that.
A completely different interaction, and to me, it's borderline. It would be borderline blaming the victim. But does the defense have to go down that road and say, "Look, These two people fine, George Floyd not fine because of George Floyd.
It's an argument that they can make, Vinny, but I think it's something that they don't necessarily want to do here because the two passengers in the vehicle with George Floyd are not being handcuffed. They don't have a gun being pointed at them. You could see that they are agitated, that they're, a little upset about the situation, but it is very different. So to use that to explain that, it could have gone a different way, I don't think would be a good route for the defense to take.
I agree with you there. Just throwing it out there with the experts, which are you guys, not me. All right, Lee, the training manual. We know the defense is going to use this because they've already used it in some pretrial motions that were filed. In the training manual, this picture exists. It's a knee on a neck from a training manual. How persuasive could this be in front of a jury?
Candidly, I can tell you this is, I think, the defense's possibly strongest weapon when they identify this training manual and connect it to the elements of third degree and second degree manslaughter, and the second degree where it has to be intent. Minnesota has never really addressed this type of procedure, and before this trial started, they said, well, this is not what we teach our officers, and then all of a sudden in defense filings, you get this as an exhibit. And of course, a lot of the filings, seasoned trial attorneys know how to educate the judge, whether they're going to win a motion or not. But most importantly, what they're trying to do is get evidence out to the public to say, look, this is what's happening. Consider this, consider that. And I think this is going to be crucial evidence for the jury, for the defense, and for the state to respond to. There's no doubt about it.
All right, we've got a lot more to get to tonight. By the way, folks, the latest episode of the Court TV podcast is now available. Of course, we're covering the death of George Floyd murder trial. A jury's been seated, opening statements expected on Monday. A key piece of evidence jurors can expect to hear about comes from the prior arrest of George Floyd. The judge in the case recently ruled that evidence is admissible, and Michael Ayala and I discuss how it might come into play. Let me bring in Court TV anchor Michael Ayala. I mean, if there's evidence that George Floyd was ingesting drugs at the time police approached him, shouldn't the jury know that?
Well, I think the evidence that can be presented should be confined to the May 2020 arrest. If they want to infer from that evidence that he took drugs, that's fine. But when we talk about the effect that those drugs had on his body, they are going to be given license to take the effect that the drugs he took in May of 2019. They're going to be able to take the same inferences and say, well, he took drugs on 2020, so it probably had the same effect. I don't think that's necessary. You're almost handing them sort of an acquittal.
You can find the Court TV podcast wherever you listen, and it's always available on CourtTV.com. We'll be right back. Welcome back. We've got a lot more to cover. Don't forget, Monday morning, it all begins. The George Floyd death murder trial. You've got Derek Chauvin on trial, opening statements on Monday, right here on your front row seat to justice. Okay, time now to go on the docket. We've got a case out of New Jersey involving another police officer. Much different circumstance here, though. This police officer accused of chasing down through the neighborhood his estranged wife, shooting and killing her after he saw her in her home with another man. Take a listen.
On an evening in July 2019, when he was on his way home from work after working a double shift, he comes home and he enters his residence and he finds his wife in bed with another man.
It may have been the ultimate betrayal to New Jersey police officer John Formazano. He and his wife were going through a divorce, and his discovery of another man in their bedroom sparked such rage, police were called to the scene following reports of gunfire.
They had long guns, and I said, this is really a real situation, so back up. And we were actually behind the engine of the truck to keep cover.
Police found 37-year-old Christine Solaro Formazano dead outside her home and a 40-year-old man found inside with multiple gunshot wounds. Moments before, a horrifying scene played out. Christine was being chased by her estranged husband as she went door to door trying to get away.
She was saying, let me in, I'm shot. But it was late at night, everybody was sleeping. Then she made it down to the next house, but he was still in pursuit of her. He walked up to her, and I don't know how many times, but you heard probably 6 pops down there.
The couple's 2 small children were home at the time. Neighbors heard police shouting to a little girl inside.
She was standing in the window. I'm guessing they thought the shooter was still inside, so they weren't going in, and they had the little girl at the window, so they didn't want her to move and to go in there and get hurt too.
Formazano had left the scene before police got there. About 3 hours later, he was found in Livingston, New Jersey, about 25 miles away, and was taken into custody. Police say he told them he was dropping off something for one of his children and blacked out when he saw a man in her bedroom.
He was nice as can be. You would never think he would snap.
It could happen to any man or any woman when those situations confront them at that time. It is a reaction that could cause any of us to black out and have a situation unfold that we did not intend.
Formazano is being held without bail in a Morris County jail.
Charging the defendant with 1 count of murder pursuant to NJSA 2C:11-3A1 and 2, a crime of the first degree, 1 count of attempted murder.
The 24-year veteran of the Newark Police Department is also charged with official misconduct, child endangerment, hindering apprehension, and weapons offenses. Formazano has pleaded not guilty to all charges and is expected to put on a mental health defense at his trial.
The defendant did file a notice of a motion, or notice of a defense rather, placing his mental state and his mental condition at issue.
That's a brutal, brutal case. Those poor kids. Let's bring back in the think tank. Michael Bixon, my friend Anthony Iaculo is representing that former police officer. Does he have any case? What is he going to argue?
I think this case revolves around the statement that we heard the defendant made that he blacked out. And it's going to sort of play into this whole insanity defense. They're going to need to negate any type of intent or purposeful killing. And if they're able to do that, they actually do have a shot at winning this case. But, Vinny, I'll tell you this, any type of insanity defense, they are very tough cases to plead either to a judge or to a jury.
Renee Hill, blacking out, but he's still able to chase her through the neighborhood and also take a shot at the boyfriend as well. And where's the line? Where is the line between, I just blacked out and lost my mind, I snapped, versus, well, that's the motive, right? The motive is this outrageous, this jealous and outrage.
And these are the things, like Michael said, that, they're going to have to parse out. He's been under psychiatric care, it's my understanding, for the past 8 or 9 months now. And they're going to have to go to the experts on this to explain what it means when someone snaps, when they black out. And can someone black out and chase someone down the street? I'm sure there are experts that will say they can, that an entire event can take place without the person acknowledging that they are understanding what's happening in that moment, in the heat of the moment, so to speak. And it can extend for a period of time. And I'm sure that that's what the defense is going to be arguing here. And it's going to be based on what the experts have to say.
Lee, it's one thing, and I think we all had that case or in law school where, someone comes home and they find their spouse in bed with someone else and they snap, right? And it goes to, what your mental state is. It's his estranged wife. They're living separately. It's like nighttime, and it just seems like he's kind of casing the joint, stalking the whole thing out. It seems like it's much more planned rather than I just happened to go there and, oh my goodness, my wife's in bed with someone else.
That's right. If I was the prosecution, I would make a big deal of that. He's a police officer. They were living separately. They were going through a divorce, which a lot of people in the United States go through. And this happened at night. Certainly, I think the prosecution has some good evidence on their side too to get a conviction. But like I always tell my students when I teach trial advocacy, there's good cases that can be lost, and there's bad cases that can be won.
We've seen it on court TV. I'm not going to mention which cases. I'm not going to do it. Michael Bixon, I'm not going to do it. All right. When we come back, it's time to hear from you, our 13th juror. And today, a real big picture question, which is, has the relationship between police and the community gotten better or worse after the death of George Floyd? We know there were protests, demonstrations, but there's also been a national conversation, and there's been some changing in policies. Have things gotten better or worse? Your verdict when we return.
They just threw something on fire, Chris, a firecracker. Something's on fire.
Part of the initial reaction to the death of George Floyd involved some demonstrations that got violent, got out of control. There were a lot of peaceful protests as well. There was a national conversation. There was a change in policies in departments around the country. And I think just more awareness of this issue, of the relationship between police and the community. So I put the question up today, have things gotten better or worse in that relationship since the death of George Floyd? We begin with our 13th juror comment of the day, coming from Lisa, who says, no, the relationship between law enforcement and the community hasn't gotten any better since last summer. Just because the police are being masked, they still have the same tactics, training, and attitudes. Lee Hutton, your thoughts. Has anything gotten better? Has anything changed? Has it gotten worse?
No, it's gotten worse. We have to address these issues. I think the police have to be transparent and accountable, and we need new policies for change.
Valerie tonight. Well, let's just say that the jury is still out on this because things happened after George Floyd, and now that the trial is about to start, all eyes are wide open, and we are waiting to exhale. Michael Bixon, do you think the outcome of this trial could impact the relationship between police and the community?
Honestly, I think the only way that it really could have a large impact at this point is if there is a not guilty verdict. If that happens, I think that we're going to see an explosion of outpouring anger and resentment against the police. But I think otherwise, I think it's just going to sort of fit into the dialogue of what's been happening over the course of this trial. But like I said, if there is that not guilty verdict, yeah, I do expect for things to sort of explode.
Douglas tonight. Actually, for law-abiding folks, it is strengthened. For non-law-abiding folks, it's the same song and dance. Watch people who are talking smack and trying to videotape every incident a cop is involved in. Renee, those videos never look good, do they?
No, they don't. But here, the video has captured a tremendous amount of evidence that is going to play out. And it's very important. You know, a lot of things have gone unsaid because they were not captured on video. And now with technology and everyone pulling out their cell phones, a lot more is coming to light because of that. And without the videos, a lot of cases would not be brought to trial. We might not be here without this video of George Floyd.
Mary Lou tonight.
It's important.
Absolutely. I agree. I think it's better, except now police are afraid to police for every criminal they arrest or make a stop or put under scrutiny. That's where it's not better. Lee, do you think there's been a pullback by police at all in terms of making less arrests or afraid to make an arrest?
Yes, I do. I mean, there's a heightened sensitivity, but on the flip side, there's a lot of black people who are scared to be black. So we got to figure out how to coexist with one another.
Angela tonight. Things have gotten worse. There is suspicion, apprehension, and a general lack of trust. This is not a racial issue, in my opinion. Too many confident egos are inflated when the badge is pinned. Whew. Michael, response to that?
There's a lot to unpack there. I definitely think that there is a racial component to the police bias. And I think that's one of the things that we've had to deal with. And I think that we have sort of moved towards in a positive way over the last year or so through the dialogue that we've had. But yeah, I do think there's still a lot more work to be done.
And our final comment from Jim tonight, no better, no worse. There needs to be more community outreach by the police, but I think the pandemic has hindered any efforts to that end. There should be zero tolerance for any racism. Information should be reported, monitored, and acted on. Education for both sides is key. Renee, do you think that the community has to do, we only have about 10 seconds, the community has to step up as well here?
I think so. I think everyone has to step up. There has to be transparency. Everyone has to step up. The community has to want to get along as well. And I think if everyone is trying, then things can get better. But it's got to come from both sides.
Renee Hill, Michael Bixon, Lee Hutton, great job tonight. Please come back very soon. Appreciate your insight and your time tonight. All right, folks, that's it for me. We'll be back here tomorrow, 8 to 11. I'm Vinnie Politan. As always, have a great night, and don't forget to hug the kids.